Okay, well, hello everyone, and welcome to Glasgow Loves EU's lockdown live stream. Hopefully not lockdown so much anymore. Tonight our topic is the retained EU law bill, and we're delighted to welcome Professor Catherine Barnard of Trinity College, Cambridge, to take us through the intricacies of this. Catherine's Professor of European Law and Employment Law at the university and a Deputy Director of UK in a Changing Europe. This is a network of academics, some of you may know, funded, I think, by the ESRC, and provides independent insights around Brexit-related issues and the UK's relations with Europe. So Catherine has often provided evidence to parliamentary select committees on the implications of Brexit-related legislation, and is regularly interviewed by the media. I'm sure many of you will have heard her on the radio and so on. So there's scarcely anyone better, I think, to take us through the implications of the retained EU law bill. So the way we're going to do this is that Catherine's going to kick off the session with some slides, laying out the groundwork. But before I hand over, let me finish the introductions. My name is Fiona Wishlade, and also with us on the chat are Dee Barnfield and Bernd Poor. Dee is going to monitor social media for questions that come on through Facebook or Twitter, and maybe Mastodon. Can we have questions from Mastodon? I'm not sure.
I get them from Bernd.
So please send in questions if you've got them, and we'll put them to Catherine after her presentation. And Bernd is making sure all the technology works for us and recording the session, which you can see later on social media. I think Twitter, Facebook, Mastodon, and YouTube. I should also say that we're also strictly non-party political organisation, and that we're affiliated to the European movement in Scotland. So I'm going to give the floor to Catherine now and ask her to share her screen with her slides. And just a reminder to those who are watching live to pose your questions, and we'll turn to them after Catherine's presentation. So I'll hand over to you now, Catherine. Thank you.
Well, thank you very much indeed for those kind words of introduction. Just before I start, Bernd, could you just tell me whether you can see my slides? And can you see them at full screen?
Yes, full screen, yes. And everything is fine, yeah.
Perfect, thank you. Now, I am going to talk to you briefly this evening about a bill which has got the most boring name, and I'm amazed that anyone might have even turned up to hear about this bill. But in fact, this bill is going to have profound effects on the UK legal system if it becomes law. So it's called the Retained EU Law Revocation and Reform Bill, and because that's quite a mouthful, it's known as the Rule Bill for short, and rule is spelt, as you can see on the slide. Now, I want to start by very briefly explaining to you, if I can just get the slides to move across, what retained EU law is, because in order to understand what it is, you need, in order to understand what needs to be changed or is going to be changed, you need to understand what retained EU law is. Now, as you can see there, the idea behind retained EU law was it was a snapshot of all EU law which was in force on Brexit Day. Now, there are a number of complicated legal mechanisms by the means of which that occurred, but the bottom line is all EU law, apart from the Charter of Fundamental Rights, was taken from the EU statute book, put onto the UK statute book, and had the special name of retained EU law. And this was done by the EU Withdrawal Act 2018. And as you can see from the Queen's speech in May 2022, the idea was to ensure continuity and stability. But the government always intended to change that retained EU law. And certainly one of the benefits of Brexit was, for Brexiteers, that it would be possible to change that law. Now, there's nothing in the 2018 Act, that's the Act which contains retained EU law, that prevents any change from occurring. And indeed, this is one of the manifestations of parliamentary sovereignty that change could be done. But the idea was that it should be done as and when we were ready to make that change. Now, what this bill is going to do is to speed up that process no end, and I'll show you how in a moment. Now, in order to understand what comes next, I want to introduce you to the three limbs of retained EU law. And those three limbs, which come from the EU Withdrawal Act 2018, cover retained EU law itself, which are things like the Equality Act 2010, which gives effect to lots of equality legislation, things like the Working Time Regulations, which gives effect to the Working Time Directive, passenger rights regulations, which allows you to claim compensation if your plane is late. All of that is retained EU law in the narrow sense. But in addition, what was also preserved was case law of the Court of Justice and domestic courts interpreting EU law. And thirdly, retained general principles of law, and that's things like proportionality and legitimate expectations. And the other thing that was retained was the principle of supremacy of EU law. And by that means if there's a conflict between retained EU law of certain sorts and pre-Brexit domestic law, in fact, the retained EU law would prevail. Now, as you can see here, this was the government's best guess of what how much retained EU law there was left on the UK statute book. And you see that on the dashboard. And this is the government's dashboard, and it contained about 2,400 pieces of legislation. And as you can see, some departments, particularly DEFRA for agriculture and BEIS, business and industry, have really quite significant numbers of bits of legislation, as does transport, and also we've got HMT and DFT there. So you can see that there's a lot of retained EU law. Now, if you want to know more about retained EU law, you can go onto the dashboard yourself and try and explore it. But in fact, they discovered shortly after the bill was introduced that although they thought there were 2,400 bits of retained EU law, they discovered an extra 1,400. So we're now talking about 3,800 bits of retained EU law. The dashboard's not been updated to accommodate those extra 1,400 pieces. Now, you may recall during the party leadership contest in the summer, the two main contenders, one Rishi Sunak and one Liz Truss, tried to compete with each other to outdo how quickly they would turn off all of that retained EU law. And remember that retained EU law are those 4,000 bits of legislation I mentioned to you here. Rishi Sunak did a campaign. He said he was going to turn it all off within his first 100 days. And there is him shredding something called EU legislation. And there it is, all successfully shredded. Liz Truss was somewhat more modest. And she said, we're going to get rid of it all by the end of 2023. And indeed, it was her who put the bill through the Commons. Indeed, she says she wanted, and this is what Rishi Sunak is now doing, to make sure it is all done by the end of 2023. So what's going to happen to this retained EU law? You've seen the politicians competing to get rid of it. Well, that's called sunsetting, and that's what they're hoping to do. And indeed, the bill says, and you can see it here, that there is a sunset clause, and the sunset clause means that all of that 4,000 pieces of legislation will be sunsetted, i.e. turned off. It will be turned off by 31st of December 2023. So all of that law, the working time regulations, product safety regulations, cosmetic safety regulations, all of that will be turned off by 31st December 2023. However, I should just be clear, what won't be turned off is primary legislation, things like the Equality Act Anything which is a statute won't be turned off, nor will anything to do with tax, nor will anything to do with customs and excise and VAT. So that is the basic plan. And this is dramatic. As far as we're aware, no other country has ever tried dramatically turning off 4,000 pieces of legislation overnight on the 31st of December 2023. Now, although the headline is really dramatic, and indeed that is the default position, it is possible for ministers to make regulations to keep some of that legislation if they choose to do so. And there are two different routes. There is clause 1.2, which if ministers make regulations to keep certain bits of law, that if that power is used, there is no time limit on ministers making regulations and regulations staying in force until the government decides to turn them off. The other possibility is the clause 2 route, the second one on the slide, and the clause 2 route says there will be a delay of the sunsetting. In other words, the sunsetting won't take place until 23rd of June 2026. Now, the crucial thing to note about this is that it requires ministers to be proactive, i.e. they've got to make a conscious decision they want to keep X, Y, and Z piece of legislation, either potentially indefinitely under the first limb or until the 23rd of June 2026 under the second limb. The trouble is there's no process for this. We don't know what happens if a minister decides he wants to keep legislation, but then does it go to the cabinet and the cabinet say, no, this is a Brexit opportunity. We want rid of all of this legislation. So this is the real concern. And remember, if ministers don't use the powers in clause 1.2 or clause 2, then you go back to the default position that everything goes. It's like a complete closing down sale. Everything, absolutely everything goes. That is the default position. The other possibility that you find in the bill is that there are extensive powers to enable ministers to so-called restate retained EU law or to revoke or replace it with such alternative provision that the minister considers appropriate, but on condition that that replacement doesn't increase regulatory burdens. Now, what this means is that ministers can use their power to chop and change, chop up, rewrite bits of retained EU law. So, for example, in the case of the working time regulations, they don't like the stuff on, for example, the 48-hour working week. They can cut that out of the legislation, and they can rewrite it, and it will be called just ordinary UK law, and they will carry on, and of course, without the benefit of having Court of Justice interpretation of those provisions. And the real fear is that if this is done very late in the day, say November 2023, if it's done very late in the day, the opposition has got nothing to do, because they say you will use it or lose it, because if you don't agree with it, it will disappear on the 31st of December 2023, whether you like it or not. So you may as well agree to this truncated provision. So what I'm saying to you is that this sunsetting is incredibly powerful. It's incredibly deregulatory. Now, if you're in favor of deregulation, then you say this is a very efficient way of doing things. If you're not in favor of deregulation and you believe that some legislation is important, then turning it all off, but with the possibility of ministers being able to keep some of it if they choose and if they're allowed, or restating it, is not a great way of doing lawmaking. Couple of other things. It doesn't have to be that way. Have a look at the Financial Services and Markets Bill. This bit of legislation does much the same thing as the Rule Bill, the one we're talking about. It turns off all sorts of retained EU law in the financial services sector, but where it differs, it's got about 300 odd provisions, because the Treasury and the Bank of England and others have all consulted on what they want the new rule book to look like. So this is a rational way of reforming the law. What's not a rational way of reforming the law is to turn absolutely everything off. And do bear in mind, I said to you that when we were looking at this dashboard, we think there is 2,400 bits of legislation. We've discovered recently that there's another 1,400 bits. What about other bits that we just haven't noticed? We just don't know is there. I'm told there's about 800 pieces of legislation, which is orphan legislation. And by orphan legislation, it means that it no longer has a relevant government department that's looking after it. So there may well be other bits that have got missed. Now, Jacob Rees-Mogg is really the father of this piece of legislation, although it was laid under Liz Truss's extremely brief premiership. Jacob Rees-Mogg is a great fan of it, and indeed has been leading the process to try and get rid of it. And as you can see, his view is a bonfire of EU laws is easy to achieve. Now, I'm afraid I mean, it's easy legally because you can do it almost with a stroke of the pen, as I've shown you in clause 1.1. But whether you actually think it's a good idea or not is another matter entirely. And as you can see here, he says, look, we've discovered it's now nearly 4,000 laws, and another 1,400 apparently been found by the National Archives hiding on dusty shelves. Now, this is, of course, a bit of prose by Jacob Rees-Mogg disguise the fact that this legislation covers things as fundamental as the safety of gas appliances or food safety legislation. These are not irrelevant bits of legislation which are just sitting there. Case law, second bit of retained EU law. Remember I said there were three parts? One, the retained law. Secondly, case law. What's going to happen to case law? Well, under the 2018 Act, that's the EU Withdrawal Act, post-Brexit case law can be used to guide courts. So decisions of the Court of Justice can be used to guide UK courts in interpreting retained EU law. But pre-Brexit case law, i.e. decisions of the Court of Justice before Brexit Day, must be followed by all courts, albeit that the Supreme Court and the Court of Appeal and their Scottish and Northern Irish equivalents have the right to depart from that case law where it is right to do so. So the highest courts in the land can depart from that pre-Brexit case law, but it's got to be right to do so. And although this language of right to do so looks pretty vague, in fact, the courts have taken a very conservative approach, and they have not been willing to depart from pre-Brexit case law. And that has been offensive to people like Jacob Rees-Mogg. And therefore, the rule bill contains a strong nudge to the courts to depart much more enthusiastically from that pre-Brexit case law. And there are various new procedures in the bill, which I won't detain you with, about making it easier for lower courts to refer matters to higher courts to speed up the process of departure, or for the law officers to intervene in cases to try and get the law changed. And there is some very odd provisions in clause 7.3 of the bill to try to encourage courts to depart. One of them being that courts should be aware that EU case law restricts the proper development of domestic law. It's extremely unclear what that means. Final thing for you to note is supremacy. Now, if you remember when I gave you that very broad typology of retained EU law, I said it's retained EU law itself, retained EU case law, general principles, and also supremacy of EU law. Now, it does look odd, it must be said, that post-Brexit EU law still trumps conflicting pre-Brexit case law. In fact, the mechanism by which it happens is rather complicated. If you look at the 2018 Act, for anyone who's a lawyer in the audience, under the 2018 Act, the supremacy principle was turned off by the 2018 Act. But then, if you dig a bit further, it's always good to look beyond the first section. Supremacy, in fact, is turned back on. And Jacob Rees-Mogg and Lord Frost said this is a very terrible thing. And so what you see in the new retained EU law bill are some quite complicated provisions about turning off the supremacy of EU law. So to conclude, because I've nearly had my time, this is a dramatic piece of legislation. It's a highly controversial piece of legislation, and it is a deeply unpopular piece of legislation. As you can see here, this is from the Financial Times last week. There's been a very broad coalition of people and organisations that want this bonfire of EU rules stopped because it will affect employment law, environmental law, food safety law, all sorts of things that we have come to value. And the problem for the government is that Rishi Sunak is in a weak political position, and because he's in a weak political position, he is very concerned about doing anything which will upset the ERG, the European Research Group, who still hold considerable sway in his party. Now, the sensible thing would be to kick this bill at a minimum into the long grass, but this bill has become totemic for those Brexiteers who have felt that the great Brexit opportunity is total deregulation. And that's what we will have if the bill goes through and if ministers don't use the powers to keep some of that law still on the statute book. Thank you very much indeed.
Thank you, Catherine. That was great. That was a really clear expose of where we are, albeit quite a frightening one. I'll maybe give Dee a minute or two to pick up any questions from social media, but perhaps I can sort of like kick off the discussion by asking whether, you know, from a legal point of view as opposed to a political one, I mean, is there any real justification for the kind of wholesale overhaul of retained EU law that you've described? I mean, would the supremacy argument fall into that category, or is it just, you know, is there a legal rationale for it?
That's an interesting question. So if you accept the snapshot argument, do you remember I said at the beginning that what happened in 2018, that 2018 Act, was that they took a snapshot of all of that body of law, put it on the UK statute book. Well, that body of law included supremacy of EU law. That's why it's there. Now, is there any justification for doing this legally as opposed to politically? I mean, it's very hard to see a strong legal justification. Indeed, there are legal arguments against. If you believe that Brexit opportunities involve deregulation, then perhaps you can make that point. But remember too that the Trade and Cooperation Agreement, that's the trade deal that we trade with the EU under now, post-Brexit, contains what's called level playing field provisions. And level playing field provisions mean that the UK, if it decides to deregulate significantly in the field of environmental law or employment law, the EU can start procedures against us, which would end up with tariffs being imposed on us. And so there are serious consequences at international level if we go ahead with this approach, not to mention the consequences for individuals who are relying on those EU employment rights or those environmental rights, who really, really want to keep that legislation.
Okay, that's really interesting. I suppose just before I go to Dee to see what she has from social media, I mean, a second question, given that we're all based in Scotland, is, you know, what does the bill mean for the devolved governments? You know, some of the policy areas will fall in their areas of competence. So how you know, what are the implications of the bill for, say, for the Scottish government, the Scottish Parliament?
Huge, absolutely huge. And the devolution provisions in the bill are some of the most complex and some of the most inconsistent. It's certainly the case that Scottish ministers can exercise those powers to hang on to bits of legislation if they so choose, but not in all areas. Of course, they will only be able to act in areas where they have devolved competence. But of course, then by exercising their powers in those fields, the risk is they engage another piece of legislation, which is the UK Internal Market Act. And that act has the effect of essentially, I oversimplify because it's quite complicated, but that act has the effect of essentially imposing English laws on Scotland. Yes, Scotland can choose to be more demanding of its producers, for example, if it's in an area of devolved competence. For example, laying down standards in respect of plastics, for example. But under the UK Internal Market Act, anything made to English standards have got to be allowed to be admitted to the Scottish market, which means that the Scottish manufacturers bear an extra cost, and therefore they're more likely than not to lobby the Scottish Parliament not to impose higher standards, because otherwise they will lose out economically in trade within the four nations of the United Kingdom.
Okay, so another scary strand to the story. Dee, do you have anything from social media that you that you want to chip in with and ask Catherine?
There are a couple of things. One is how much scrutiny, if any, is going to be given to this. You know, the other parties and MPs and committees and things going to have any input. And the other thing is to do with the dusty shelves. Will there be any? Can you anticipate any traps we might fall into, re-scrapping something that we really need and then find that nobody noticed it?
I think those are both excellent questions. On the first one, Labour is very engaged in this, particularly Stella Creasy, and it's thought that the Lords will put down a number of amendments to the bill. But ultimately, the government can ram it through because the Lords can only hold it up for a year. And so that's why there is a huge push by all of those interest groups when I showed you the excerpt from the FT. And also, there are 10 very tentative signs of business putting its head above the parapet now, saying all of this creates huge uncertainty. If you were listening to the Today programme this morning at 6:25, and the CEO from Siemens was saying that they are reluctant to invest in the UK because they have no idea what the ground rules are, and what business needs is legal certainty. And that's the problem about delaying the abolition of retained EU law until 2026, because it just creates 3 more years of uncertainty, and therefore 3 more years when businesses may decide not to invest. On your second point about dusty shelves, the question is absolutely right. The default position is that absolutely everything will go unless ministers have opted to save it. But if ministers don't know it's retained EU law, by definition, ministers won't be able to opt to save it. And there may well be bits of legislation that no one has spotted. It is somewhat alarming that after all the work that's been done, when we thought there were about 2,500 pieces of legislation, 1,400 extra ones had been found by the National Archives. And there may well be others. It's just because, in order to understand it, if you think about Lord Denning's image of the EU law form part of the tributaries, the rivers, the tributaries, the streams of our system, we just don't know, because there is no accurate list of all of retained EU law, which is why it was very sensible in the 2018 Act to say everything is saved, because it's much easier to be all embracing and say everything is saved, and then we'll start to unpick the threads as and when we've done the relevant work, which the Treasury and the Bank of England have done in respect of financial services. But instead of having that much more careful, consultative approach, what this bill does is slash and burn to get rid of the lot.
Yeah, that's really quite frightening. And of course, I mean, the UK as a member state would have made a major contribution to the development of that legislation in the first place as well. But
Fiona, that's a very good point, and indeed it's one of the arguments, going back to your question, it's one of the arguments why Lord Frost says he wants rid of that law, because he says it's undemocratic, because the Westminster Parliament had no say over that legislation. But I'm afraid I think that's somewhat disingenuous, because Westminster did have a say over that legislation through its representation, both in the European Parliament and, more importantly, through the Council of Ministers.
Yeah. I mean, the dashboard that you showed us, indicates like a vast range of policy areas potentially that are affected. And I mean, for sort of like our non-legal audience, I mean, and can you give us some sort of like practical examples of the kinds of things that could happen, you know, from things being sunsetted in the way that you've described?
So possibly the working time regulations, bathing water, quality of bathing water directive, measures on the safety of gas appliances. Nearly all food safety legislation comes from EU law now. It's the passenger rights compensation. I mean, it's just endless. Lots to do with air safety. Now, I imagine air safety will be one of the areas where they do decide to exercise the powers to keep those rules in place. But the trouble is, you just don't want to miss them. And, you know, for all the focus on air safety, which of course something we all have passionately care about, you know, there are other areas which are not of such general interest, but may be very important to particular groups. So this legislation, it's not, as Jacob Rees-Mogg suggests, some sort of archaic, unnecessary red tape, which is the standard jargon. It is absolutely essential, fundamental legislation. Now, if the UK was going to propose different, better legislation, so be it. But because they haven't done any consultations about replacement of that legislation, it's slash and burn without anything being put in its place, unlike in financial services, where they are going to get rid of the one set of rules and replace them with another.
Yeah, so there actually is a model that you could use in order to sort of like carve out certain sort of safety net for certain sectors if there was the will to do so. Dia, do you have another question from social media?
Yeah, there's a specific one from somebody on a particular area, which is if the UK loses data protection adequacy, what effect would it have on business?
Really serious. So there is a data adequacy decision between the UK and the EU, and there is actually, to be fair, there are special provisions in the retained EU law bill on data adequacy. But if we decide through other processes that we want to get rid of GDPR, which is what the government is talking about, then that will have a serious effect on businesses. There are certain ways around the problem, but it's incredibly bureaucratic, and it will make trading with the EU even more difficult.
That's not great news.
Yeah. I mean, one of the things that you mentioned in your presentation is about, you know, the criticism that there's been of the bill from increasingly from business, also from trade unions, but also from the Regulatory Policy Committee, which said that the government's own impact assessment was not fit for purpose. And I think its best mark was on its assessment was to say that it was weak.
Yes, this is extraordinary committee. This was set up by BEIS, the Business, Enterprise and Industrial Strategy Department, and they have used that committee to check the quality of UK legislation. I have never before seen a report like that one, which you mentioned, which was published, I think, last week, which is so damning of a piece of legislation which essentially BEIS has been leading on, because it was originally run from the Cabinet Office until Jacob Rees-Mogg went to BEIS under Liz Truss. And indeed, I think it's still sitting in BEIS.
And I mean, given the given that kind of criticism, and I mean, I guess it's a political question, which you partly touched on already. But I mean, what are the chances of this bill making it through to the statute book in its broadly its current form?
Well, there were signs that Rishi Sunak was beginning to see the error of his ways, and it's certainly his commitments in the summer that all of this law would be gone within 100 days look like one of the many commitments he made, which is he's not going to stand by. I think Rishi Sunak is somewhat more pragmatic than Liz Truss had been, and I think he is aware of the really very serious implications of this bill, but he is in such a weak position politically And particularly after last weekend's brouhaha over that the UK might enter some sort of Swiss-style arrangement, which of course set all sorts of hairs running, and of course led to apoplexy by the European Research Group. That Rishi Sunak has got to carry on burnishing his leave credentials. And of course, the best way of doing that is to carry on with the retained EU law bill, presumably in the hope that government departments will get their act together and try and use those powers to delay the sunset. But even BEIS itself, which had, before they discovered the extra 1,400 pieces of legislation, even BEIS, which has about 350 bits of legislation, said it would require 400 staff to work on it in order to look at those, I think about 350 bits of legislation before the 31st of December 2023. And, you know, the question is this a good use of civil service time? And is a good use of public money for civil servants to be pouring through all of this legislation to check whether it should be kept on the statute book or not?
And am I right in thinking that there's a kind of like a trigger point in the legislative process before which the civil service doesn't really expend resources on looking at the detail of things? So is there a kind of like a chicken and egg problem there of actually knowing what the scale of the problem is before the legislation's gone through? That's
right. And some of this legislation runs to many tens of provisions, which are very complicated. This is not just a one-page, one item bit of legislation. So this is a huge amount of work. Now, it may well be that, you know, as the sunset, assuming the bill becomes an act, it may well be that as the sunset approaches, you eventually see ministers being forced to agree to huge swathes of bits of retained EU law being kept because they haven't got time to even manage the process because they've just run out of time. You know, the 400 staff haven't been able to deliver just in BEIS. And of course, it's far worse in DEFRA. I think it's probably got better now, but when the bill was published, I think DEFRA only had 3 people working on it. And, you know, this is, I mean, they just don't have the capacity.
Yeah. Okay. Dee, I think you've got another question from the audience.
I think you've probably pretty much dealt with the first one. I'll just read it out just in case there's anything extra. How feasible is it that departments and Parliament can deal with this vast exercise in a very limited period that's been set? Is slippage likely, possibly beyond the lifetime of this government? And then kind of related, if there was no political motivation to include a sunset clause, how long would it normally take to thoroughly review this volume of legislation? I'm just going to add one of my own, which is, do all the people reviewing it need to have some legal background to be able to kind of go through and assess, you know, the stuff that they're reading and, you know, that kind of thing?
Yeah, thank you. So on the first question, as I've already indicated, the departments need a huge number of staff to work on this. And it's not just the departments, of course, as the questioner rightly said, it's also about parliamentary time. And then, of course, the extra component that's of relevance to you in Scotland is, of course, there really should be discussion between how it's going to be delivered between Westminster and Edinburgh, and indeed Westminster and Cardiff, and Westminster and Northern Ireland, where, of course, the problems are even more complicated. Now, of course, in this very compressed timetable, it's just not possible to do that work properly. Do you need a legal background? It would help very much to be able to do that, to have a legal background. There are quite a lot of policy people who do understand this area of law, but remember too that there is huge churn in the civil service. And with the churn in the civil service, of course, you lose that expertise. They're very good generalists, but not necessarily specialists. How long would it take to revise this legislation? It's a fair question. I mean, if it was done properly, it probably would take years, possibly decades. And certainly what we saw when countries left the UK and got independence, essentially what they did was more or less what I've just described when the UK left the EU, essentially screenshot, they wouldn't have said it then in the 1950s, but screenshot all of the pre-existing legislation, and then over time get rid of it as and when they were ready. And some of it's still on the statute book, so it can take decades. And clearly the government wanted to be able to show that there were some Brexit benefits, and this would be, for example, turning off whole swathes of retained EU law.
And can I just come back on Northern Ireland, because it's is it even more complex with Northern Ireland? A, because there isn't a government sitting at the moment, and B, because they're part in the EU and part not in the EU because of being in the island of Ireland.
Yes, absolutely. But of course, the Northern Ireland Protocol Bill, which is also going through Parliament at the moment, aims to turn off essentially all of the Northern Ireland Protocol, with a couple of exceptions. And that means that none of the EU law which applies in Northern Ireland will continue to apply in Northern Ireland, with one or two exceptions. And so if the Northern Ireland Protocol Bill goes through and becomes an act, it will remove the problem you're alluding to. But the trouble is it will create many other problems, not least very likely a trade war with the EU.
Oh, jeez.
Yeah, I mean, maybe one final question, because we're like approaching the end. Is you know, whether you've got any thoughts about what it says or what it implies for the role of Parliament, for sovereignty, for ministerial discretion, and whether if the bill went ahead, at least in some form, that would have a long-term impact on the kind of like the balance of power between the different arms of the Constitution.
I think that's a really interesting question. I think I would say two things. First, Jacob Rees-Mogg says that retained EU law is undemocratic because it was adopted by the undemocratic EU. I've already dealt with that point. But even if you accept that point, when the whole body of EU legislation became retained EU law, it was delivered by a British Act of Parliament, Westminster Act of Parliament, the 2018 Act. So it has democratic legitimacy that way. And so it is more, the 2018 Act is democratic under our system. What's alarming about the retained EU law bill, like the Northern Ireland Protocol Bill, and like any number of other bills that are going through Parliament at the moment, is just the number of powers that are given to ministers. So these bills are essentially skeleton bills, and huge powers are delegated to ministers using the mechanism of what's known as Henry VIII clauses. And these Henry VIII clauses allow ministers by statutory instrument, i.e. secondary law, to amend primary law, acts of Parliament, without bothering to go through Parliament. And yes, Parliament can object to the process, but the last time a statutory instrument was rejected was 1979, so don't hold your breath.
Okay. Well, I think we need to wrap up there. We've taken a good chunk of your evening, Catherine. I think if anybody was in any doubt about the enormity of the implications of this pieces of legislation before our chat, they won't be now. Thank you very much for sharing your expertise and being so generous with your time, and we'll all be following you closely in committee proceedings and in your work with UK and Europe as well. So thank you very much for joining us.
Thank you very much. Lovely to have met you all, and thank you to the audience for giving up your